Your latest Murgitroyd webinar will start in a few moments. For more information on today's panel and our company, visit murgitroyd.com/webinars.
Hello and welcome to the 8th series of Murgitroyd online seminars. We are delighted to reconnect with our regular listeners and a warm welcome to those of you tuning in for the first time. Our webinars are here to keep us all up to date on the latest developments in the world of IP. Please don't forget you can submit questions via Twitter using #Murgitroydwebinars and remember to tag us at Murgitroyd. You can also contact us by email at webinar@murgitroyd.com or by posting your questions on the control panel. So, let's go straight into today's webinar.
Hello, good afternoon everybody. I'm Catherine Bonner, Director Patents at the Murgitroyd Southampton office, and I'm here this afternoon chatting to Eleanor Coates, a member of our Brexit team here at Murgitroyd and a very experienced trademark attorney. I'm very excited because I'm going to find out a lot today about the certainty that we have in uncertain times about Brexit. We hear it on the news every single day, and we're trying to navigate our way through the territory we find ourselves in. I get questions from my clients all the time about this, so I'm really pleased to be sitting here with you, Eleanor, so you can talk me through some of the aspects that you've been looking at and the advice that you're able to provide at this time. Thank you.
Hi, Catherine. Well, I hope I don't disappoint. There is quite a lot of certainty towards Brexit in the area of trademarks and designs. We obviously had the potential for Brexit to have occurred on the 31st of March this year. And as a result, a lot of the legislation about what will happen, whether there is a deal or no deal, was put into place at that time. There are approximately, I think, 7 or 8 statutory instruments which went through and all became legislation before the 31st of March. And these provide quite a lot of certainty, so we can see what will happen to registered trademarks and registered designs. For UK registered trademarks and UK registered designs, there's actually no change because they are obviously governed by the UK IPO, the UK government, and there's no change. They just continue as usual. It's really, if you've got a portfolio that covers EU trademark registrations or EU registered designs, technically known as registered community designs, these will no longer, after the UK exits the EU, cover the UK. They will just cover the 27 member states. The EU IPO has been quite clear on that point. However, that does not mean that you, as a potential owner of trademarks and designs, would lose your rights to the UK. The UK government has put into these statutory instruments legislation which will ensure that you are given automatically and free, if you have a registration, a new comparable UK trademark registration or registered design.
Okay, so there's no loss of rights there at all?
No loss of rights at all. The situation is not quite the same if you have filed an EU application and at the date of exit it has not registered. You can still keep your rights and request to have a comparable UK application created. The difference being is that you must make the request and you have to pay the application fees. You would still, your UK comparable application would be able to still have the filing date equivalent to the EU application and will mirror the details of that application, but it will start the process a little later because you'll have to go through the examination in the UK, and as I say, you'll have to pay the application fee.
A difference in cost there.
There is a difference in cost. If, in the scenario, we were to exit on the 31st of October, then it's unlikely if you filed an EU application for a trademark that it would be registered in the time frame. An EU registered design can actually go through in 4 to 5 weeks, but a EU trademark will take much longer.
You're right in that. I've had, I think, some instances where applications for registered designs have gone through in a matter of days. Just incredible. Sometimes it happens.
Well, it is a deposit system, but generally we would say 3 to 4 weeks, maybe 5 weeks, but unless you have an issue arise. But at this time, if you are launching a new product, which perhaps may require a design protection or a trademark protection, it could be advisable just to actually file both a UK and an EU application if you are requiring protection in both jurisdictions.
Yes, to start the process off with both now, yes. Yeah. I should have said if there are any questions during the webinar, we can take those. And if there are any questions that this webinar causes people to think about and they come back to later, we have a specific Brexit email address. So that's brexit@murgitroyd.com for any Brexit-related queries. But yes, this is answering a lot of mine already. So thank you, Eleanor. Thank you.
There are a couple of additional factors that unregistered owners may wish to consider. One is that if you get given a UK comparable registration and it was due for renewal just after the exit date or in the 6 months after the exit date, and you renewed it with the EU IPO, you would still need to renew it with the UK IPO. So even if you renewed your EU registration in advance, because you can renew a trademark registration 6 months in advance, if you did take that advantage of that early renewal period, you would still have to renew the UK registration as well, the comparable UK registration.
Double renewal fees, okay.
Yes.
That's very interesting, very interesting. The situation that I am coming across at the moment with the portfolios that I handle, a lot of patents and patent applications, is really we don't have as much to talk about. There's no change. It's business as usual. The European patent rights are administered by the European Patent Office under the terms of the European Patent Convention, and neither of those bodies are linked to the EU. There are members of the European Patent Convention, countries such as Morocco and Turkey, and very many that are not EU member states. So there are more countries within the European Patent Convention, more member states than there are EU states. And the discussions that I often hear, there's a lot of confusion between the unitary rights for, as you say, the designs and the trademarks registered at the EU Intellectual Property Office and patents for the European Patent Office. So I have less change coming my way, really, with the patents and the patent applications that I manage, yes.
But more explaining to do, because it does sound like the European patent would cover.
Absolutely. Really, no change, business as usual. Not only will the European Patent Convention, European Patent Office not be changed at all in the event of the UK leaving the EU, be that on the 31st of October or at a later date, but we will continue to act and to prosecute those patent applications throughout this very uncertain, ever-changing scenery. And indeed, we have uncertain times ahead, but we're here to extract the certainty that we can at this time, which I think our extensive network of offices helps with that, yes?
Yes, it does, particularly for trademarks and registered EU designs, because UK representative firms will not be able to represent before the EU IPO, and you do require to be represented by an EU-based attorney firm. Thankfully for us, we have offices in Dublin, Munich, Milan, Nice, Helsinki, all of whom are going to be able to be representatives for our clients, and there's no change to our clients' aspect of it.
Yeah, overall I think direct representation in 14 EU member states. Fantastic.
Yes.
And Switzerland as well.
The other factor to talk about, you mentioned you didn't think there'd be much involved for patents. Would that also be the case in coexistence agreements? Will that arise at all?
I think that we would have to go back and check the wording there. That could have well have mentioned in one line, broad brush, across all EU member states. And that will be changing.
Yes. I mean, generally, though, what I can say from Trademarks and Registered Design perspective is that where an agreement refers to an EU trademark registration number, it is in the legislation that it will be deemed to also refer to the comparable UK trademark registration or design registration which is created. You can as well, because the UK IPO have actually issued their new numbering system for these rights, you can actually, if you're creating a coexistence agreement now, actually put that numbering in. What the UK IPO are intending to do is they are going to use the same registration number as the EU, but they're going to use that 8-digit number and they're going to add UK 0009.
Brilliant, brilliant. Already in place, the numbering system.
Yes.
Excellent.
And then, as I say, the comparable registration rights will issue automatically on the 1st of November. And we will certainly be sending out our clients reports informing them of these comparable marks and their new numbers and checking for renewal dates for them.
That bit is certain.
I mean, there are a little pieces of aspects to IP which are uncertain. One of these is if anyone has any EU customs applications for actions which have been filed through the UK customs authorities, they will revert to only being covering the UK. So you may additionally need to look at filing an EU customs application for action application through one of the customs authorities in a different member state.
I have heard they can be very effective. Remind me again about the customs notices.
An EU customs application for action, it really is a customs watch. It means you're alerting all of the custom authorities within the EU member states to actually watch out for particular products, and they can stop it coming across the border. You only have to make one application through one customs authority, and it is automatically replicated and sent to all of the customs authorities. So if you are having issues with counterfeits, or you're aware potentially of a counterfeiter, say in China, trying to bring products in, perhaps for a trade show in Germany, you can actually file that customs application watch and then have those goods stopped at the border across the EU. So if they divert and try to bring it in through Bulgaria, you likewise can stop that.
Brilliant. Okay, that's very, very useful. Very useful to know. But that tweak now would be that you would need one per for the EU and for the UK.
That's right, yes. And the other aspect, which is not 100% certain yet, is this protected geographical indications and protected designations of origin. The UK has yet to set up its own system. This does mean that some of our UK's designations will lose their protection in the UK. Now,
examples
I'm
of
talking
these
about
would be
Scotch whisky, your Melton Mowbray pies, your Cornish pasties, all of which have this status. A lot of these organisations, like the Scotch Whisky Association, have been lobbying government, quite strongly on this. And the latest sort of news is that the UK government is committed to getting this system up and in place in time, but obviously still not there. So
and time is of the essence at the moment. Yes, I think they are hugely important. Those standard marks, the fact that you're able to refer to Scotch whisky or Melton Mowbray pork pies, that something must be put in place. That's really, really crucial rights, those.
Yeah, so we do hope to see that addressed shortly before Brexit actually occurs.
Thank you. That's been really interesting, Eleanor. I'm sure we can take some questions, and I'm thinking of a couple I have already. Thank you.
So, Catherine, will your rights of representation be altered with the Brexit?
Interestingly, it's not the same. A UK trademark attorney will not, as you said, have rights of representation anymore after any Brexit before the EU Intellectual Property Office. But for patents, no change, business as usual. UK patent attorneys will continue to have rights of representation across Europe at the European Patent Office, because the European Patent Office is not an EU body, so it's an entirely separate form of protection, entirely separate system that is not linked to the EU. So any representation rights that I currently have will continue to work and be in operation. I can continue to act for my clients at the European Patent Office after any Brexit. It does get muddled and gets confused because the intellectual property rights are often lumped together. I spend a lot of my time saying, no change. Patents, I can still act for you before the European Patent Office, no change at all.
Oh, well, that's great. It must be very comforting for your clients. Although, I would say from the point of view of trademarks and our registered designs where there is a change, we'll just be working extra close with our colleagues in Dublin and Munich and the other offices.
Yes, who we already work closely with as it is. Yes, I completely agree, Eleanor. I think one right we haven't touched on so far is the unregistered design rights.
That's right, yes, because at the moment there are differences between the two rights for unregistered designs in the UK and the EU. The EU gives a much stronger unregistered design right, but it only lasts for 3 years, and it arises when the design is first disclosed. The UK current unregistered design right is a little bit more complicated because it can last for up to 15 years, but only 10 years after it's been put into production, and it's a little bit more complex. But when the UK exits the EU, obviously they will not be covered. Designs which are disclosed first in the UK will not be covered by that EU unregistered design right. And it is quite an important right because a lot of industries such as fashion, where perhaps there is a high turnover of new designs, do use this design right.
Yes, I've heard it used a lot in the fashion industry and also in the fast-moving consumer products market. So food items like that as well, I think, rely on that quite heavily.
However, it is again something where there is some certainty. The UK government will ensure that all unregistered community design rights which exist at the point of exit will continue to be protected and enforceable in the UK for the remaining period of that protection. So if, for example, your design right, you disclosed your design right 6 months before Brexit occurred, the UK government would still honour that design right for the 2.5-year period after the exit date.
Excellent.
And in addition to this, the UK government is also going to create a new unregistered design right in UK law which mirrors the characteristics of the unregistered community design. So that will really assist. It's going to be known as the Supplementary Unregistered Design Right and will operate alongside the existing unregistered design protection.
That's great. No loss of rights, continued certainty and continued established rights for those people who are using that right in those industries.
Yes, and it's a really good news if you're an intellectual property owner of designs or trademarks, because it does provide that certainty that really is required at this time.
Yeah, no, thank you very much. I think we've covered all of the intellectual property rights that might be affected at this present time. That's been a really interesting chat. I've really learnt a lot. Thank you, Eleanor.
Thank you.
Hi there, thank you for joining us today. I hope you enjoyed my earlier discussion with Catherine Bonner. I'm now joined by Russell Thom, a Director of Patents, for our question and answer session. Good afternoon, Russell.
Good afternoon, Eleanor. It's great to see so many people have joined the webinar today. Thanks all to those that have submitted questions. Eleanor and I are going to now try and address as many of those as we can today. The first question comes from Sam in London. So, Eleanor, perhaps you could pick this one up. At the moment, the SI for legislation required for the UK IPO to clone trademarks has not been passed. And with Parliament having been closed and then just recently reopened, it seems unlikely that this will happen before 31st October. In the event of a no-deal Brexit, how will this affect EU TM holders?
Well, good question, because obviously closure of Parliament does throw a little bit more uncertainty. But thankfully, the legislation, as we discussed earlier, has actually all been passed. The legislation was put through Parliament in December 2018 and January 2019, and all came into effect prior to the exit date of the 31st of March 2019. We do have more uncertainty, as we mentioned, in relation to the system for geographical indications. DEFRA is going to be responsible for that, and the latest news there is that it's going to publish its guidance on how to apply for a UK GI and the rules for doing so in October 2019. So the system may be in place by the 31st if that is the exit date, but we are cutting it fine on the GIs.
Thanks.
Russell, we've had another question in here. This is a bit more patent-based, so I'm going to ask you to answer. It says, will Brexit affect SPCs, supplementary patent certificates?
Good. So Catherine had mentioned that in general it will be business as usual for patent protection, and this would also apply to SPCs. So in summary, there's no change. So SPCs, or supplementary protection certificates, are an important area that relate to patented pharmaceutical and agrochemicals, and it's a portion of European law that provides for an additional period of protection after the patent has run out. So whilst they're not as numerous in comparison to patents, they can be incredibly valuable to pharma companies. So the relevant EU legislation will be retained in the UK law in the EU Withdrawal Act. So essentially the existing systems will remain in place and operate independently from the EU regime. So this means that the EU legislation on supplementary protection certificates will be kept in the UK law and will form the UK's own SPC regime on exit. So effectively, supplementary certificate regime in the UK will continue to operate just as before for the UK and for the EU.
A bit of clarity there then. We've had another question in. This is from John in Southampton. He's asked, are there any actions that people should take now in relation to their portfolios? I mean, I'll start this because certainly most of the action would be in relation to your trademarks and designs. The first thing really to do is, we mentioned on the recording that looking at UK comparable renewal dates and potentially think about filing a separate UK application are potential actions. But other than that, reviewing your portfolio for EU trademarks and EU design registrations to assess if you need to take any action, you will be having UK comparables created, so you may wish to consider if they are going to be a duplicate of protection and if they are required, because you can opt out from having these. You also would want to be looking to see if they have any security interests or license recorded against these. Now, in actual fact, the benefit of such a recordal may not go to the trademark owner, and it may be in the licensee's or the owner of the security's interest to check this point. These recordals will not automatically be copied over onto the UK comparable rights. They will require a separate recordal to be made before the UK IPO. The UK IPO's reasoning is that you cannot have a recordal created until the right is created. So you're going to have to think if there are any on your EU registrations and then apply to record them again. You get a 12-month period to do so without any loss of right. A further point is that if you have EU trademark registrations or designs and they've undergone an assignment, but you've not yet taken the step to record this before the EU IPO, you could do so now, because if you wait till after Brexit, you will have to do that recordal against the UK comparable right again separately before the UK IPO. So that's another factor. Russell, is there anything you can think of from patents or designs that you'd have to
So I think in general, as I say, for patents it will be business as usual. I think looking at agreements and also in terms of structures for any deals that may be done post-Brexit will really be a change in landscape there, and so worth considering. So I think definitely it's more on the trademark side, and
yes,
some action will be required.
One further point I have just thought of is the fact that EU trademark registrations may not have been filed with English as the first or second language. If that is the case, the UK IPO will be using the specification from the English translation of the EU IPO record. So it is worth having a look to check that that translation is really reflecting the foreign language of the specification. It can be, because these translations are computer generated, you can get small tweaks. For example, if you filed for the word compactors in German, now that could mean compressors in English, and that may be what you want to protect, but it can also be translated as compactors, and that tends to be the EU IPO's normal translation of it, and they are very different products.
Yeah, no, excellent point. So I think we've got time for one more question. Back to patents, I think, in a bit more detail. So I think the question that we've had there from France is, will Brexit affect the UPC? So the UPC is the Unified Patent Court, and it's a proposed new court that will hear cases relating to European patents and the proposed new unitary patent. So as Catherine had touched on, then European patents have been granted kind of outside of the kind of EU framework, and so will continue as they have done. The UPC is an international court which has been established through an international agreement, and at present it's unknown exactly when and if it will come into force, because it's been considered by a constitutional court in Germany. So at present the UK has ratified the UPC agreement, And really the operation of the UPC will depend on when Germany issues, the German court issues its decision. The German government's also indicated that they won't ratify the UPC until the Brexit situation has been clarified. I think many consider that the UPC would be stronger with the UK being included, but really the outcome will kind of remain a bit uncertain until there's some clarity with Brexit. If the Unified Patent Court does come into force and the UK needs to withdraw from the Unified Patent Court, then one aspect would be that UK businesses would kind of use UK courts to enforce the UK rights, but they would be able to use the UPC in relation to other EU contracting states. So whilst they would and everyone else would be using the UK courts, the UPC would still remain an option. But that's really a wait and see. So some uncertainty there at present, but no change from the existing mechanisms that are in place.
Okay, that's great. I was just quickly going to go through to one last question, just because it was on designs and we haven't actually done a question on designs. There's one question which has come in asking about if we've any specific advice for design holders. As discussed, EU design registrations do get transferred and get a UK comparable right. The only point perhaps to note with that is that if you have deferred publication on an EU registration, you will therefore have to file a UK application as well. There is the unregistered community design won't apply to the UK, but the UK government has setting up its continuing unregistered design to replicate the protection which will last for the remainder of the period if your design was created, say, just before Brexit.
Okay. No, well, thank you very much, Eleanor, for that kind of last point. So I would just like to draw the webinar to a conclusion and thank all those that have listened to the webinar. Thanks again to Eleanor.
And thank you for joining me this afternoon.
We've reached the end of today's presentation. To find out the topic of our next webinar and to register, visit murgitroyd.com/webinars. And whilst you're there, why not keep up to date with our latest content by subscribing to our mailing list? Thank you for your valuable time today and for all your questions. We hope you found the subject matter relevant and well explained. Should you have any other questions or wish to discuss the topic further, please contact us at webinar@murgitroyd.com or via Twitter @Murgitroyd. Until the next time, goodbye.
Our business is founded on trust and collaboration. The subjects we choose for our webinars are topical and informative. We are always looking for suggestions for new topics for discussion, so if there's an area of IP that you are keen to understand better, please drop us a line at webinar@murgitroyd.com.